Thank you. Hello, everybody, and welcome to Ask the Experts. It's kind of fun to see many of your faces and know that we do have this amazing expertise. And I want to say, if we could get Frank Strigari and Blake Esselstein given moderator privileges too, that way I can ask them questions. All right, so it's been a really full day. And one of the things that I've taken away from this is that this nation has the expertise. The question is, can we share it with each other? And that is exactly what we're doing here. So I really love that piece of what's going on. I also noticed that a lot of the expertise that we brought to the table really came from legislative staff people. And that means that when people get that expertise in whatever decade it is, and then they share it around, it really works. So I'm pretty impressed with legislative staff from around the nation. And in terms of participants, I see that we have people from 45 states with us. So that makes me feel really good too. I don't know if NCSL has ever done anything that gets over 45, so that's pretty much at the top of the heap. What we're going to do today here is ask Christy to do a little bit about upcoming events, then a quick review of a couple of agenda things, and then we're going to get right into questions. You're welcome to put questions in the chat box right now if you'd like to. Christy, fill us in, please.
All right, thanks, Wendy. I just want to mention a few events. On January the 27th, NCSL will be having its 4th census update meeting, and that will be at 2 p.m. Eastern. We will be joined by Kathleen Stiles, Chief, Decennial Communications and Stakeholder Relationship at the Census Bureau. Also, NCSL will be holding an educational series for new legislators and legislative staff. And for those who are new to a particular committee or subject area, the content will be at a 101 level and will focus on state policies and federal laws in cases where they may overlay with state policies. That series will be held on each Friday in February. So keep your eye out for more information. And lastly, I want to mention that the elections and redistricting team holds office hours twice a month. This is a virtual meeting for you to speak with our team on any elections and redistricting related topics. The next office hours will be held Tuesday, January 12th at 1 p.m. Mountain Time. These calls are intended to be informal, so questions are welcome. And then 2 reminders. NCSL's redistricting law book is available, and it's a wonderful comprehensive guide for the upcoming cycle. Legislators and legislative staff can receive a free copy at no cost. And for seminar registrants who are not with the legislature, the book is discounted from a price of $95 to $49. So just to let you know that that is available to you. Lastly, just a reminder that all sessions except Friday's optional session will be recorded, and those sessions will be available to you for 30 days after the end of the seminar. So you don't have to miss a thing. Thanks.
Great. Thank you, Christy. And Christy, there's a couple of questions in the chat box that I think you can probably answer easily. What's happening next in terms of this meeting is that at 4:30, any of you who are still interested in making choices around software and vendors have the opportunity to see 4 of them in operation. So for those who need that, that's going to be the coolest thing ever. For those of you who don't need it, it's probably a must miss. So you get to decide for yourself. And tomorrow morning, we have the clerk of the New Hampshire Senate who will lead us in yoga at 8 a.m. Eastern time. No, 8 a.m. Mountain Time, 10 a.m. Eastern Time. We've seen her do this before, and we had Clark Benson and Kim Brace and Peter Watson all doing yoga with her. It was a total blast. So if you can join us for that, that's great. However, you have a choice at that point, because we also have NCSL's Kurt Stedron teaching about negotiations. And I just want to tell you that if you think that people on Zoom are a little flat, you're wrong, because Kurt is so alive. So both of those are great options. You get to decide what you're going to do. And then tomorrow night, of course, we have trivia with Tim Story extraordinaire, and I'll put that in the chat box in a minute so you can get all of the details on that. But he wants to make sure that that's fun and that that gets shared around. So with that, I'm going to go to questions, and I have several questions about the census. James, I think you're there, and if that's the case, be prepared. The first is that given the delays in receiving PL 94-171 data, what are the options or best practices for states that have state constitutional deadlines for redistricting that will be impossible to meet? And James, maybe that's actually not right for you. Maybe that's more of a Jeff Weiss question. Jeff, can you come off mute and answer that one?
Sure. States that have early deadlines, whether they're constitutional or statutory, are really in between a rock and a hard place on this. Everybody should be looking at their end date in terms of when 2022 petitioning or qualifying for office starts. But to enact your plan with the census data coming as late as June or July will present a problem. And you might have to do what California has already done by going to court and asking your state Supreme Court, or depending on your state's laws, the appropriate court for relief. California had to have their first iteration of plans out by, I believe it was July 15th. Obviously, they're not going to be able to meet that deadline with late data. So the speaker and the president pro tem went to the state Supreme Court after adjusting some of the dates internally through statute, and got the state Supreme Court to agree to extend the constitutional deadline from July 15th to December 15th of next year. And New Jersey passed a constitutional amendment to extend redistricting from 2021, since Virginia and New Jersey are early 2021 redistricting states. They put it off by constitutional amendment approved by the voters until 2023. So you should look at your state's laws, your state's precedents, and see what you need to do to accommodate the dates, the timetables. Worst case is that you may have to use your current lines one more time. It's happened in Mississippi and Virginia 30, 40 years ago.
Wow. Okay, coming right at you with some more on the census. Several of the presentations mentioned concerns that the census data may not be accurate enough to be fit for use, and that this issue would likely be litigated. What, if anything, should states do about this concern when using census data to redistrict in 2021? And Karin, if you're there, I'll call on you. I'm not sure that you are. Otherwise, I'm gonna turn to, I'm looking at my suspects here. Frank, is that something you want to weigh in on? You don't have to.
Okay, sorry, I'm just trying to hit the button. Yeah, you know, that's something that I don't have a lot of thoughts or insight about, to be honest with you.
Okay.
It's uncharted territories. I
Yeah.
actually will be interested in hearing from James, just to hear if they're having any administrative conversations internally, but he can talk last if
Yeah, well, I don't see James here. Is he with us?
Oh, I see him there.
Oh,
Yeah,
great. Then
Karin
James-
and I are both here.
Oh, great. I just can't see you on my screen. Great. James, do you want to address that? Maybe that you don't feel like that's right for you. So the question is about what, if anything, should states do about the concern about data quality?
Yeah, I mean, I can't really comment on the issues of litigation and around the data once it's published. But what I can say is that with the differential privacy, one thing that I think has not been well communicated by the Census Bureau is that the demonstration data sets that we've been producing, we did the initial set over a year ago for people to look at, so that people could look for and apply their use cases and try to identify any biases they might have seen in the data. And then when we continue to improve the algorithms that are behind the differential privacy mechanism, we purposely held our privacy loss budget to the small privacy loss budget that we used for that original data set, so people could see that any improvements that we were making were coming from refinement to the technique and not from us just bumping up or reducing the privacy protections. So I think that that's been a common misconception, and I know that we're working very hard to make sure that when the data is finally published, it will be fit for use for the use cases that we consider these primary use cases, such as redistricting. But I can't comment on litigation because that, as you know, is out of my realm.
Oh, got it, got it. Karin, I think you're able to unmute now. Can you take another stab at that? I know you kind of addressed it earlier today.
Yes, thank you so much. Thanks for unmuting me. And thanks for this question. I disagree with James just a tiny little bit about whether or not these data, based on what I know now, are going to be fit for use. Unfortunately, what the people that have worked with these demonstration data sets have found is that there are significant issues with these data. They affect various jurisdictions. And one use case that I am personally very, very concerned about is that for prison populations, California, of course, has to reallocate its prison populations. The census is not holding the group quarters populations invariant, which means that they are going to give us a different data set than that data set that we received from the Department of Corrections. So there is an automatic error, which means that there's probably litigation coming our way. And that just does not sound like it's fit for use. Fit for use means that I can actually do the work that I need to do, that the legislature has asked me to do on behalf of the state of California, and not get sued right out the door because I don't have proper data to do it. So I think what states can do is talk to their state demographers, talk to the many groups that are currently working on raising their concerns with census, open that dialogue, realize that the census is not over, give the census enough time to revisit their disclosure avoidance system, perhaps come up with different methodologies, or tune up this particular methodology that they are using to the point that the data will be put out in a way that is accurate, significantly more accurate than what we're seeing right now. So we need more demonstration data. Please just communicate that to your member of Congress, the transition team, and to NCSL.
Thank you, Karin. I'm going to come back to you, Frank. Jump in again, please.
Oh yeah, I just want to make one point specifically too. Like I talked about this a little bit earlier about there's a lot of concerns about how census litigation will be an issue in the upcoming decade. And to some extent, maybe this might be a little bit of a defense of James in the census, is that I think the one thing that if we can try to prevent from doing is just assuming that it's going to be wrong or it's going to be bad, because I think that's not going to help the process if we're just assuming that there's going to be fatal flaws with it. Because as we all know, with any previous censuses, they're never perfect. But and I know that they're working hard on their own side, and that. But we obviously there's a lot of legitimate concerns. Karin just raised a couple in California, so we just probably need to just respect the process as much as we can, though, too.
All right, I appreciate that thought, and I think that for me, some of you know this, that my mantra for 2020 was stay calm, and my mantra for 2021 is be flexible. And I think that's what we have to do in regard to the census. We will adjust in some way or other to what's going on. I mean, I think there's little doubt that they're working their tails off over there. They've just got some major things to deal with. Okay, I got a couple more things. James, you've said it before, but when in 2021 can one expect to begin drawing maps using census data?
Well, I can say that the underlying mapping geographic files, we'll start getting those out the door at the end of this month. Or towards the 22nd of this month, and we'll have it delivered to all 50 states, DC and Puerto Rico, no later than February 28th. And I'm quite hopeful that we might even be able to do it to finish up a little sooner than that. The redistricting data itself, it is still a work in progress. Those of you who tuned into the census session earlier, I tried to explain the point that there's two things that we're dealing with. One is, of course, with the pandemic delays, and the redistricting data is hooked to the apportionment data. So we can't actually start creating the redistricting data until we have some outputs from the apportionment process. And as you know from the recent news, we have not yet made or have not yet delivered the apportionment data. The second issue is that in our in the desire to compress the apportionment schedule to try to get the apportionment data out as close to the statutory deadline as possible, we had to change the way we process the data. We used to do several things as we prepared for apportionment that were also for preparing for redistricting, but it was only used for the redistricting part. And we've had to decouple those so that we only focused on the things that were needed for apportionment. So we're going to have to redesign those and put those back into the pipeline to make sure that we're producing the quality redistricting data that you expect from the Census Bureau after we get the quality apportionment numbers out. So all of those things being said, it is going to be a difficult and challenging operation to get that put back together. I'm very hopeful that we will be able to, once those apportionment numbers come out and we have the certainty of the inputs that we need, that we'll be prepared to very shortly afterwards give you a timeline for when to expect the redistricting data.
You know, James, earlier today, I had to write something up for legislative leaders about the census. And what I realized is that the press is sort of saying you guys are taking too long to do your post-enumeration processing. But in what I was trying to put together, I realized you've actually been trying to shrink it from a 5-month process to a 3-month process. So it shouldn't be a surprise to us that there are some anomalies that come up with it. So, you know, if you'd had the full 5 months, we would have never known. This would have all been behind the black curtain. I think we've got Jerry Berry on the line, and I want to ask you a little bit more about criteria, because you just did a fabulous presentation for us on that. 2 questions, maybe just one. I thought I had them grouped. Do states which don't list redistricting principles, such as compactness or community of interest, adhere to those principles when they draw boundaries?
Well, they are not required to adhere to any of those principles. Many of them do. If a redistricting plan was challenged in court, the courts generally apply the traditional redistricting principles when they're looking at a plan. So it behooves states that are not required to adhere to those principles to still follow them. And I think it's just a good practice to do it, but they are not required to do it.
Great, thank you. And the next question is, what is the current legal state of affairs regarding prisoner populations and congressional redistricting? And I can just go ahead and say that 7 states have said that they will use prisoner reallocation, that's the phrase, to do their redistricting this coming year. And I believe in all 7 of those, they plan to do it for congressional and for legislative lines. Karin, can you tell us some of the hurdles or points that states that are new to that process will need to be thinking about?
Yes, of course. Thank you, Wendy. California is going to implement this process for the first time, this round of redistricting. And some of the issues that we have encountered are pretty obvious, probably to everybody on this call. We received a data set from the California Department of Corrections and Rehabilitation. And while they collect data, they collect data on their inmate populations, and those data have race and ethnicity and so forth attached to them, but they collect these data differently than the Census Bureau. So when you're trying to match these data up then with the data that we're receiving from Census, this is disregarding the fact that differential privacy is going to make this almost impossible. These 2 data sets will not match. Furthermore, what we've seen is that many of the previous addresses that the inmates used to reside at before they were incarcerated are perhaps not addresses that are either in existence or they're not entered properly. They may not be in existence anymore. So there's an enormous amount of data cleaning that has to happen. So it's basically just general problems that you run into when you're dealing with administrative data. And I could only urge people to start working on this very early. And if anybody has any questions, or again, I always say this, if anybody wants to start a user group of people that have to do this, please just contact Wendy. She'll put us in touch with each other and we can work through these issues together.
And James, I'm going to come to you in just a moment, but I do want to say that there is support from the couple of states that have already done this. That's New York and Maryland, if my memory is serving me at this point. And there's something called the Prisoner Policy Initiative. And we may at NCSL pull together people, staff from the 7 states that plan to do it for a little bit of an exchange about this. I've heard that you need to build in at least 2 weeks for that data analysis before you do it. And James, could you tell us a little bit about the data that the Census Bureau would be providing on that?
So the one thing that we changed about the redistricting data set for this decade to help states who have that state statutory obligation to make these reallocations of population is we're providing what we call a group quarters table as part of the redistricting data set. It's a table that identifies a group quarter by group quarter type. So that would be something like a correctional facility for adults, military barracks, student housing, all of which come into play depending on which state you're in for the reallocation obligation. And we provide that at the individual census block level. So you'll be able to see where census has counted those group quarters. You'll be able to see what the population that census reports in those group quarters. And then in addition to that, we're also, if states have a large list of addresses and they want to take advantage of the census geocoding service that we have, externally it has a 10,000 address limit. But for states that are working on redistricting, we'll allow them to submit their through a secure system, their address list that's pre-formatted to us, and we'll run it on the backside on the server against that same geocoding service so they don't run into timing out issues or things like that. And we'll return it to them the way that system outputs the geocoding service. So that's the two things we're doing to help people who are trying to do that work.
That's great. And I see some good conversation in the chat. Jerry, I did have a second criteria one for you. Can objective criteria, compact districts, minimal split of municipalities, avoiding incumbent contest, strictly applied, create a judicially manageable standard to evaluate a proposed map?
Wow, there's a lot to that. I think, you could make that argument that would be a proper standard to use, but whether courts are going to go along with that, I don't know that there's that I can answer that one.
Okay, well, that's totally fine. I heard about that in Pennsylvania. There was a influential citizen who said, look, I know how to measure splits, but I don't know how to measure communities of interest. So I recommend you, Pennsylvania, just use these measurable ones. That wasn't the way it ended up there, but I remember understanding that point that you can count the number of splits, but some of the other things are harder. Blake, I'm going to come to you next. The question here is, can rigorously applied objective design criteria, wait, nope, wrong one. Hang on. Oh, I think I doubled up, sorry. Then the next question I've got, I don't know if this is right for you, Blake, or not, is what is the evidence that independent commissions draw better or fairer maps? And I bring that to you knowing that tomorrow, Peter Watson will talk about that at some length. He's been sort of measuring the success of maps drawn by commissions versus legislatures for several decades. But Blake, do you have anything you'd like to add in that? Blake, do you have, you may not have the power to unmute yourself yet. Is there someone else who'd like to?
I think I'm available now.
Okay.
It's a good question, and I think I would also direct people to Peter Watson's presentation tomorrow. I've heard things from reform advocates, certainly, who will tell you about all the reasons that state processes with independent commissions have been preferable or drawn better maps. But it sounds like Peter Watson has done a more thorough and kind of objective analysis.
Yeah, and I'm remembering there that the Brennan Center has a different perspective, but I can't remember what it is they measure. So that question will have to stay a little bit up in the air, but we will quiz Peter carefully tomorrow.
Wendy, can I just mention?
Yeah, please.
The Massachusetts Senate and House did a joint report on their redistricting after 2011, and they maintain that legislatures often do a better job than commissions and end up in less litigation than commissions. And that's before Peter's done his research on post-2010 activity. But my own research informed me over 10 years ago that state legislative plans often withstood judicial scrutiny more than commission plans did.
That's been, I'm pretty sure that's what Peters is going to show, or that they're neck and neck. I don't know who's a good person for this question. Can a state pass its own law requiring a pre-clearance trigger mechanism and state level pre-clearance office? I know.
I could answer that.
Okay.
New York actually has a bill pending in both chambers to do just that, to require a state attorney general pre-clearance process for voting law changes. Maybe Corinne can speak to it, but California also has its own Voting Rights Act.
Washington State does too. Karin, you want to say something on that?
Just agreeing with Jeff, we have the California Voting Rights Act, of course, that is basically designed to look at jurisdictions, local jurisdictions that have at-large elections, that have significant minority populations, and in which no member of the minority, protected minority group has ever been able to get elected. And under certain circumstances, you can force that jurisdiction to go to district-based elections. And what it basically does is it differs from the Federal Voting Rights Act in that it does away with the geographic compactness criterion. So that's a big difference, but it doesn't really apply to what we're talking about here right now.
Okay. So that's an interesting question, and it'll be, I could imagine that some states might look, as New York is, at that question for themselves. I do want to say that anybody else who wants to jump in, you do need to put it in the chat so I know to be able to get you to have the ability to unmute yourself. And we will have time for some extra questions. I still have 2 or 3 more here from earlier in the day. This one is that the US Constitution requires that the states have a Republican form of government. Could a partisan gerrymander to create a single party state go so far to allow a federal challenge? And I will point out that in Hawaii, the Senate either has 1 Republican or 0 Republicans in it at this moment. So Frank, is that something you want to tackle?
Sorry, I say the last part of that. Say the last part of that question. I didn't hear it very well.
Could a partisan gerrymander to create a single party state go so far that it would allow a federal challenge? I think it's saying, is there an outer limit to the federal allowance of?
That would be an interesting provision to raise a challenge under the federal constitution for. But again, I think it comes back in a sense to the fact of, if it's partisan gerrymandering challenge under this separate provision, I would have to think that the courts are still probably not going to be, the federal courts are not going to be very interested in wanting to hear it, given the recent decision that came down. Now, that was based under a different provision of the U.S. Constitution, of course. But I think the fact that if we're just talking partisan gerrymandering, I think you're going to see a lot of federal courts, and the federal court probably not want to hear it. But
thank you for letting me unmute. I asked that question back earlier, and the context was really in a state that's fairly closely divided. This actually was something that came up when a number of us were looking at the back and forth with Gill versus Whitford in Wisconsin, where the state was pretty evenly divided. It was pretty clear from the analysis that you could essentially create a state plan that was invulnerable even to a very strong electoral wave and essentially lock in one party's control. And the question would be, if you, rather than contest Wisconsin on a First or 14th Amendment claim, why not contest it on a claim that they had essentially violated the claim that they still had a Republican form of government, because the party could never change, even if you had, a tremendous wave in the other direction. That was what it was. Actually, a real question that actually showed up in an amicus brief as well, that showed up on that case.
Well, that's very helpful to have the context for it. Thank you, Mike. Let's see, another question, and I'm going to go to you, Gina. If you're not the right person for it, that's okay. How do you respect communities of interest while not allowing packing and cracking that secures the surrounding districts for a specific party? Gina, are you able to answer that question? All right, who else would like to tackle that? You've got to respect the communities of interest, but you also shouldn't be packing and cracking.
I can talk about it a little bit. Again, in the context of California and how we implemented this in the last redistricting. Packing and cracking usually refers to Voting Rights Act compliance. And that is a higher criterion, of course, in every state than preserving communities of interest. I think communities of interest are often misunderstood in that they are very frequently not very large. Oftentimes, communities of interest can be neighborhood groups, for example, or neighborhoods for that matter, historic preservation areas, a redevelopment area, things like that. Basically, communities of interest can run the entire gamut. So it is generally possible, I think, to do both carefully. I think that's one of the tricky things about redistricting that comes up when people talk about automated redistricting, where people think they can just, where some of the software developers think they can just throw everything into one pot and then it's going to come out okay. You do have to look at it carefully and you have to weigh your criteria and you do things one at a time and it works out somehow. It's not easy, but it does work.
Wendy?
Yeah.
There is a Supreme Court case that discusses that, albeit a little bit prehistoric. In 1964, I recall, in the decision Wright versus Rockefeller, it was alleged that the creation of a African-American congressional district violated the 14th Amendment. I believe the court came down holding that Harlem, which was the community in question, was a naturally occurring community of interest. So you might glean some information for those interested from Wright versus Rockefeller.
Oh, wow, that is what we get when we have people who've been studying this for quite some time. Thank you. Gina, I think you're now able to unmute yourself. If you'd like to jump in on the communities of interest one, that's great. I've got another one for you as well.
Okay, yeah, sure, I'd like to. I really do agree with what Karin was saying, that your Voting Rights Act issues and things like that would take priority over communities of interest. I think those are the legal requirements that you have to meet when you're drawing those maps. That doesn't mean you would just not look for those communities of interest. And we do rely upon a lot of our legislators to help us know where those are in their areas and their districts so they can guide us to communities that should be held together if at all possible. They might be areas that are not an incorporated municipality that identify as just a local region. It could be a school attendance zones. We have some counties where that really is a big deal for them to know where their children all attend the same high school. So if you can keep them in one district, then we try to do that. But I do think that comes as a lower priority below making sure that you comply with the Voting Rights Act.
Yeah, that's true, that the Voting Rights Act will always preempt any state or local criteria. It would be a violation of a federal law.
And I'll do the other shameless plug for the Red Book on this one too, is that I think one of the points that with the point we're making here, and I agree with Gina, is that communities of interest is considered what we talked about in the Red Book to be an emerging principle as compared to the traditional principles of compactness, contiguity that we've always heard about. So yeah, and as Jeff just said, Voting Rights Act is going to ultimately be superior to it, but doesn't mean the community's interest shouldn't be considered though.
I was thinking about the Red Book myself there, Frank. Things that we knew 2 years ago are slipping out of my brain, but they're held tight in that book. Gina, let me try this one on you. Asking for best advice for both legislators, nonpartisan staff, and the public to prepare for a legislature's failure to draw a map and therefore the court ultimately drawing one. And we know that in Minnesota, that's what happens all the time, that the legislature doesn't, or it lasts 2 or 3 decades, and that the courts have to step in. So here you've got the legislators, the nonpartisan staff, and the public. What should they do to make sure they get it over the finish line so courts don't have to, or is it okay to just let it happen?
Well, I mean, I think that would be your last resort. You don't want to get to the point where you have to let the court draw your map. So making sure that you work together as much as you can and try and, I know as nonpartisan staff, it's hard to kind of mediate sometimes, but sometimes you're in the role of trying to do that to help steer the process along and make sure that there is a map that's passed. It can be very difficult when you have a lot of different opinions on what it should look like. But hopefully your target is not to just give up and let the court draw your map, even if you know it may result in litigation. You still want to go through the process and be involved as much as you can and try to help everyone understand that it will be better for them to adopt a map, especially if you're drawing it legislatively, not as a commission. But if you're a legislature drawing the map, it's better for you to draw your map and do what your job is in that respect than to just let the court have it. And I know sometimes it happens that way, but do your best to try and work through the issues together.
Yeah, it's better if you can get it done on your own. And then I would think that if it is going to the court, it's good for you to be a friend of the court. And I mean that in a small f kind of a way, to give whatever support or data you might be able to have. Peter Watson would be an interesting person to talk about that with too, because he is from Minnesota where they do that on a regular basis. Blake, we have a question about what are some model strategies for seeking and obtaining public input to the redistricting process. That would be, for instance, how to get maps from the outside and structuring public hearings. Anything to offer on that?
If I may, Wendy, that was another one of my suggestions for NCSL to put a working group together or a user group together to figure this out, because whatever we've done in the past, now that we're in COVID, I think, you know, everybody needs to get together and just figure out how we're going to do this the best way possible. Clearly, this is all dragging on a whole lot longer than we had anticipated. And so there's going to be a lot of hearings that are going to be over Zoom or some other technology. So generally speaking, I think accepting maps in whatever way, shape, technology that you can is a good thing. Just be transparent. You know, translate. Don't have people show up and then have them scream at you that you didn't, you know, provide translation services. Just kind of be proactive on it. Put as much information as you can on a website. Start a project website as soon as possible. And I think the more information you can provide and the more ways you can provide participation access, that is the model. So for us, again, I mentioned this earlier, we designed our own community of interest input tool for California that our commission is going to use. So that's going to be helpful. I think now that people can't really go to meetings, it's going to cut down on, you know, hand-drawn tiny little neighborhoods that somebody has to digitize. So, you know, look at what's available. There's free tools out there. There's free COI tools out there. There's redistricting tools out there. And, you know, let's do a user group.
And I appreciate what you said. You told me that before, and I put it on the after this meeting agenda to begin to put together. Public input does seem like it comes up over and over and over and over, and we're all looking for ideas. Jerry, are you there? And do you have any Colorado ideas you want to throw in?
Well, in Colorado, we've had a constitutional requirement that we hold hearings in each congressional district for the last, well, since 1974 is when the initiative passed. So we do that, but I will caution you that I think times have changed, and even 10 years ago, we didn't get a whole lot of input from the public. Most of the people who showed up at those meetings were from the political parties who had their own agenda all the time. I think it's going to be different this time because it's been publicized more that this is an issue around the country. And I mean, the ability for the public to draw maps is going to be much better than it was even 10 years ago. So I think it's one of those emerging issues that, yes, we're going to have to deal with.
Thank you.
Wendy, I'm able to speak now. I think Karin and Jerry made a lot of good points. A couple other things. I mean, sort of rules of thumb within the planning community is to try and go where the people are. So I think Jerry's point about actually holding meetings in congressional districts, if we are able to have in-person meetings, but you know, some congressional districts are also huge. So to think about really trying to have places where people can meet in the areas where they live, thinking about hours. You know, if you're holding your public hearings during the workday, a lot of folks aren't going to be able to attend. So I know California has looked at having meetings at different times of the day and week, and just generally looking at blind spots. If it does end up that things are still virtual through this process, what about people who are not computer savvy? So thinking through the folks who might not be able to attend or participate, given the channels that are sort of the low-hanging fruit to provide, and moving beyond that.
Perfect. And that digital divide question is so important in literally everything we're managing in the time of COVID.
Wendy, you might want to actually even hear from Mike one, because we had a competition 10 years ago in the state of Ohio, for which I believe, Mike, correct me if I'm wrong, you were the winner of it, right?
Mike Portner.
Now, I don't know how many submissions we wound up having, but he needs to be unmuted probably. But he was the winner of it, and he might be able to provide some perspective on whether that was effective or not.
Well, that's great, because I was going to come to him next.
Yeah, okay. I'm live now. Thank you. Thank you so much. Yeah, thank you, Frank. You are correct. What's interesting is that was unlike, I know there were a number of states that did various types of public competitions 10 years ago. What made Ohio unique, because I looked at a number of them, was it was very much judged just on objective criteria. And that made it very different. A lot of them, they put up panels of judges to judge the different maps, but Ohio used objective criteria. And my background, besides being a legislator and kind of getting the politics of it, I am now retired, but I'm a PhD physicist, a professor of physics at Northern Illinois University. I served for many years. And so I kind of used what I knew about the mathematics to really try to optimize. And I made a comment that in chat, there's a paper from the 1970s that for all these people who say, well, I can use a computer to draw a map, that in fact, it's been mathematically proven that you cannot guarantee the best solution with any computer program, theoretical or practical. A computer, on the other hand, and this is what happened in the Ohio thing, a computer makes a brilliant judge if all you have are objective criteria. And that's what Ohio did. They said, the computer isn't going to draw the map, the computer is going to be the judge of the maps. Because in fact, they put up a map that a computer had drawn, and many of the human participants beat it. So you have to know what the limits are of computability and objective criteria versus subjective, and can you make some of the subjective criteria more objective when you're trying to compare maps? It's a really difficult mathematical problem. That's before even getting into how do I deal with the VRA, which is entirely driven by subjective court cases.
Great. Mike, I have another question for you, but I do want to call everybody's attention to the chat box. We do have some ideas about how to help people who don't have computers be able to participate. And as always, libraries across this nation are holding up their part of our society. So Mike, my question for you is from a nonpartisan staff person who asks, what are some tips for dealing with hyperpartisanship on the part of legislators within the redistricting process? And of course, I ask you this because you are recently retired from wearing your legislator hat.
Sure. No, in redistricting, it's just very hard because, not only did I serve in a legislature during a redistricting cycle that was entirely partisan at that time. It was, I was in the minority sides where we weren't given any role whatsoever. And it was, that's just the way Illinois historically does it. But I also worked with some county organizations, advising them as well on redistricting. And yeah, it's really hard because for a lot of members, this is their livelihood. And, this is like, fighting for a job. And it's as important as the election itself. And it's really, really hard There was a comment, and I'd have to go back and look at my notes as to who said it, but I think to the extent if one can at least say, here are the priorities, and I know a lot of states do have priorities in the form, or at least priorities in process. How is this going to proceed? To make sure that that is all laid out in a way that creates some openness and transparency. You can at least go to people who are being over the top and say, we've got a process here. Let's go through the process. On that note, I mean, it was that kind of process and procedural that in fact, I presented it, I guess it was almost 3.5 years ago, when we did automatic voter registration. I led the amendment fight there. We were able to do it bipartisan in the end. It was unanimous in both chambers.
Pretty cool. I remember being in New Mexico at one point and a legislator saying, this was maybe 18 months ago I was there, and a legislator said, I'm still bruised from what we went through in 2011. And I think that this legislator's thinking was, I don't want to get bruised like that again, so maybe I'm not going to be quite so ready to go to the max. Just an interesting thought. Philip, I want to unmute you and ask you, you put something cool in the chat box, but I've already forgotten what it is. Please speak.
Thank you, Wendy. I just wanted to bring to people's attention that aside from whatever constitutional or statutory deadlines they might have, that there's a whole process that takes place after the lines are adopted. There's a lot of administrative work that goes into it from the standpoint of the elections officials to implement what's been done. And oftentimes that's forgotten about in this process. And I just want people to be cognizant of it. I've spent some time recently working at a board of elections and implementing, and the timelines that's often permitted is very insufficient to make sure that the voters are properly assigned to their new voting precincts and so on in time for the elections. I was wondering what the experts here think of that.
Well, I know that we have a session on the handoff, which we think of as the handoff from redistrictors to local election officials later in the seminar. And it's something, after working on getting a prisoner use group together and a public input group together, the third thing on our list that will be helping out with redistricting going forward is to look at that handoff. Can GIS be used? First of all, are we sensitive to the timing? And that's what you're asking. But are we sensitive to the fact that we're handing data off in a way that may not be usable by the local election officials when they've got it? So I really appreciate your bringing that up. And we might want to have an offline question. Frank and Jeff, I want to ask you this question. Blacks make up 28 to 32% of the population in Alabama. How can we ensure a fair process with an accurate distribution of seats? Frank first, and then Jeff.
Well, that touches on a little bit, I think, of what I was trying to explain earlier when we were talking about racial gerrymandering. I was reading actually a little bit about it even afterwards again too, is that the courts are the concept of having a majority minority district made up of a certain percentage of a racial population is being frowned upon more and more. And the courts are starting to steer away from that as much as possible now. But obviously we have a long tradition of precedent in the state that requires, a certain population to have the ability to elect a person a candidate of its choice though too. So having a fair map that's distributing that population of the state, it's going to be an interesting way, a path to see forward on it. I'm not really sure there's an easy solution to it right now, other than trial by error. The courts do not want you to use race as the main factor ultimately in drawing a district, but that does butt up against a little bit the traditional concept of a majority minority district. And so, Jeff, you're a longtime expert on this as well too. Maybe you'll have greater insight on it, but other than me, I'm not really sure there's an answer to it right now.
Well, Alabama is the right state to bring this question from because the Supreme Court ruled in the case of Alabama Legislative Caucus versus Alabama mid-decade on the number of minority districts. And as I mentioned this morning, for those of you who are on, you'll probably hear tomorrow, the only effective way to know how many districts to draw that effectively represent minority voters is to do the racial voting analysis, whether it's a rich regression analysis, the King analysis. For each separate district, you're able to determine in advance whether you have racially polarized voting and the number of minority voters are necessary to draw an effective district, which could be 50%, could be 58%. There's no bright line number. And the mistake so many states made in the last 10 years plus was to draw these artificially inflated districts that then ran afoul of the 14th Amendment and strict scrutiny. So, take the time and the money, spend the money to do a racial voting analysis to see whether or not you are required to draw districts that the Voting Rights Act would mandate. I'll just mention in Ohio, of all places, Frank, after 2000, a lawsuit was brought against the state for the failure to create enough minority districts, and the federal court ruled based on having the plaintiffs themselves. I was one of the plaintiffs' lawyers. The plaintiffs were unable to prove legally significant racially polarized voting in key Ohio urban areas. So it might be a complicated issue, but the math is all there. That's going to tell you what you need to do.
My opinion about Jeff Weiss might be changing now since I'm now learning he was an attorney in that case. But but I think the key, but to be serious though, I think what the key two words that he said in that answer right there too was in advance. I think that's really the most important thing to know, is have that study or analysis done well in advance of actually finishing any lines.
Wendy, I'd like to chime in on that a little if I could.
Yes.
So in 2011, we had a situation that came up in one of our areas where we did have a concentration of minority population, and we had 3 majority-minority House districts in that particular municipality in that county, and that they elected African-American members to our House. So we looked at the data and the numbers in that area, and we could tell that those numbers there had not been much growth. Matter of fact, there was a loss of minority population in that area. And we were concerned, could we continue to maintain 3 majority-minority districts there? Because if we did, we could tell that the numbers were going to be significantly lower than what they'd been before, and maybe not even majority. And so we actually approached those 3 legislators, and we sat down with them and we explained what the situation was, and we let them offer their opinion on what they thought that those districts should be like. Should we combine them and try to make 2 majority-minority districts now and maybe one that would be a little bit of a swing district, or should we try to maintain 3? And where did they have thoughts on if those would be electable for them? And they said, no, do the 3. And so we did the 3, and they were barely over 50% majority minority, but all 3 incumbents were actually reelected in those districts. So I think getting the feedback too sometimes from the members of the minority groups, that's great to have. And they, they definitely have insight into their communities and what the areas they represent and what they think the electability is for those districts.
That's a great story. I really appreciate it. And it's also a good lead into my next question, which I had queued up for you, Gina. How is drawing districts protecting incumbents different than drawing partisan maps to protect an incumbent seat? I'm not sure I fully understand that, and it came in earlier, but what can you tell us about drawing with the intention of protecting the incumbent?
So I think the question is kind of maybe leaning towards drawing a district that would benefit an incumbent or that would be to their advantage, as opposed to not pairing 2 incumbents in the same district. Maybe that's what they're going for. It really depends on that being one of your criteria. I know for some states that's not even a criteria to worry about incumbency. If it is, it really depends on how much input incumbents have in the process of actually drawing the maps. I don't think that we met with all 236 of our House and Senate members before to get their opinions, but they were shown maps and there were definitely feedback. So I don't know that there's quite as much drawing the district for their benefit as people would think there is. But as far as looking at incumbency and trying not to pair them, I think in our case, that was something we looked at kind of after we had a working map in place to see then how many incumbents did we actually pair. We knew there would be some simply because we had growth in one part of the state and we had a less growth or a loss of growth in another part. And when that happens, you're naturally going to have you're not going to be able to draw as many districts there because there's just no population. So you end up having pairs of incumbents there. I think that happened for us we had about 4 pairs in South Georgia, and then we had additional pairs in the metro area. So it's going to happen. I think you're going to have that if you're looking at incumbent protection. You're going to see that you're going to end up sometimes having to pair them. But if you're considering that at all, it can depend on your priority if you want to do that at the beginning or if you want to just look at it after the fact. Sometimes it's easier to look at it after the fact and then adjust it if you're going to consider incumbent protection.
Very interesting. Jerry, do you have anything extra on that piece to throw in? Because you've also drawn actual maps where actual legislators had their districts on the chopping block.
Well, we've certainly had to face that with the rural areas of Colorado. And unfortunately, there was one representative who in 2 successive rounds of redistricting was paired with another in his caucus and chose not to run until we have term limits as well. So he was able to ultimately run again. But it is an issue that you try avoiding, but sometimes it's something that you just can't avoid.
Got it. Now, I have 2 more questions, and these both fit the realm of speculation and politics at the federal level. So I sort of almost hesitate to bring them forward. One relates to the Senate, one relates to the Supreme Court. So with that hesitation in mind, here we go on the first one. I guess I'm going to ask Frank and Jeff to each respond, or unless anybody else wants to look at these. Given the change in control of the US Senate, what do you see as the possibilities and prospects of explicit federal legislation about redistricting?
Well, I will let Jeff talk about that again, but we hit that specifically in our conversation earlier. Is that, you know, I mean, basically these are based upon the conversations he's had separately with people, but apparently there's a strong possibility that there's going to be some type of we're going to see HR1 from the last Congress like all over again, and potentially with some voting rights issues in it reemerging, which, as I just said previously in our conversation, which will be an extremely divisive piece of legislation if that comes about. But Jeff, you have the inside track more so than I do, but I think it's definitely something that's going to be on the horizon.
Mm-hmm.
Well, as we were all busy working on redistricting for the last several hours, within the last hour, Politico, New York Times, Wall Street Journal have all come out announcing that the U.S. Senate has split 50-50, giving Democrats control. So suffice it to say that Voting Rights Act legislation will probably make their way through through both chambers, but with a tied Senate and a narrow majority in the House. You can't predict now that there will definitely be a new Section 5 Voting Rights Act trigger for preclearance. One problem in the bill, which I pointed out to the congressional staff that wrote the bill, is that they don't know where it would apply. I looked at my own home state of New York and asked, what will this mean for New York? And no one knew. I think the bill as written would go back and look at your Voting Rights Act violations over a 25-year period, where I think 10 or 15 violations, somewhat undefined in the bill, would cause the state to fall under preclearance, which might be a much broader sweep than what Section 5 had under the 1960s formula. And members of Congress are going to look at it in terms of, what does it mean for my district or my state? And although I've warned the congressional drafters about those kind of pitfalls, now the rubber hits the road. Members are going to want to know, will this put my entire state under Section 5? And these are questions that have to be asked that might then drive, where the vote goes.
And
So
and a,
still-
and a follow up to that really quickly too, the whole reason why Section 5 was invalidated by the Supreme Court, I don't know, in the past decade, was because the data had not effectively been updated on looking at the relevant states that were under pre-clearance in a number of decades. And so, you could probably tend to hear what my opinion is about this type of thing, but like if they are really going at this from a standpoint of like, we don't even necessarily know, I would have to believe the courts are not going to be that's going to face some tough scrutiny if not a lot of background and effort is going into figuring out how to come up with these categories of states. But just my 2 cents.
The Supreme Court knocked out the Section 5 trigger, which is called Section 4, because it used very specific 1960s era data to compensate for that. In the current version of the bill, it covers a go back of about 25 years in history, which would mean through 2021, making it much more current. Question then goes to what kinds of violations? Simply Section 2 violations, enough old Section 5 pre-clearance objections. I've begun doing the research on that in New York, and New York hasn't had a pre-clearance objection since 1999. That's 12, 13 years of no objections under Section 5 before it was knocked out in 2013. So there will be a lot of questions, but leave it that, for a number of reasons we need not get into now, there is a need for stronger Voting Rights Act enforcement. I'll also mention that many states, and some of you may be on the call from those states, have seen laws enacted that the minority community finds to be abhorrent, rolling back voting rights because there was no Section 5 pre-clearance. So this will call for a spirited debate.
A spirited debate or a huge, an even broader schism. Gina, I'm going to bring the last question to you, and if you're not the right person, you can say so, but you come from a state that was certainly under Section 5 before. Will the Supreme Court, and by the way, if anybody wants to continue talking, I'm going to just open the floor when I'm done with this, but will the Supreme Court, as now constituted, continue to assume that compliance with Section 2 of the VRA is a compelling state interest?
Can you say that again? I think I missed part of it.
Yeah. Will the Supreme Court, as now constituted, continue to assume that compliance with Section 2 of the VRA is a compelling state interest?
Well, I think so. I mean, it's our understanding that Section 2, we still have to do everything to comply with that. So I don't expect that there'll be any change in that. I'm not sure if that answers the person's question, but I definitely think that it is definitely an interest. It's definitely one we're going to consider and have to consider in all the maps we draw moving forward. I don't expect there to be any change in that.
Right. Well, so are there any people who'd like to share in a comment as opposed to a question at this point? I guess I need to see a raised hand for that because we have to go through the how to get you unmuted. Do we see any raised hands? Any? All right. I'm going to say that we are good to go. This has been quite the day. It's been quite the day inside of our little meeting, and it's been quite the day in Washington after yesterday being quite the day. I hope that everyone sleeps well tonight and comes back tomorrow ready for digging in yet again. Let's start with that yoga, a good calm way to start your day. Or we could learn to negotiate first thing, which could be useful in the redistricting universe. We're not sure. And then we'll top off the day with trivia tomorrow. Any last comments? All right. Thank you all. See you tomorrow. Bye-bye.